What's new with the H-1B $100,000 fee? That's what we're talking about on today's episode of Live at Lunch. My name is Emily Sumner with Sumner Immigration Law. You're probably maybe tired of hearing about the $100,000 H-1B fee, but there is actually encouraging information that USCIS posted yesterday. As you may know, the $100,000 fee comes from a proclamation that President Trump gave in September. I think it was September 19th. And until now today is October 21st, until yesterday, October 20th, we really did not have information other than on the ground practical experience about the implications of this fee. Who would apply to specifically, who would it would not apply to, and what to expect next. So that is what we're talking about today. Like I said, thankfully, finally, yesterday, USCIS published some additional clarifications on their website. So first of all, who does this $100,000 fee apply to? The website says that this fee applies to H-1B petitions filed on or after September 21st of 2025 on behalf of beneficiaries who are currently outside of the United States and who do not have a valid H-1B visa. So that's really important to know, right? Because that means that when I say H-1B beneficiaries, that means the foreign national for whom the H-1B petition is being filed. If they are outside of the United States, and if these other elements are met, then yes, the $100,000 fee potentially applies to them. This is encouraging news. We'll talk in a minute about who does not apply to. So it's not encouraging if you meet those requirements, of course. The fee also may apply if you request consular processing. So if you're filing an H-1B petition, and even if the beneficiary is here in the United States and you request consular processing, by that, I mean there's a box that we mark on the H-1B petition forms that indicates that the person is here in the United States, file an extension of their status or a change of status, or something along those lines. In other words, you want the person to remain in the United States and maintain their H-1B status or change to H-1B status. That's if they're here in the United States. Consular processing means that either the person is overseas right now or they're here in the United States now, but instead of extending their H-1B status or changing to H-1B status, they plan to leave the United States, get an H-1B visa stamped, and then re-enter the United States. So for those situations, and there are some situations where even though a person is here in the United States, there are some situations that for strategic reasons, historically, we have chosen to file through consular processing. And those situations, unfortunately, the fee, it looks like, would apply. In addition, the guidance or the information on the USCIS website says that if a petitioner, so an employer, organization, the person filing, or entity rather, filing the H-1B petition, if we request on the H-1B petition a change of status, an amendment, an extension, an H-1B transfer would be included in the extension. In other words, if we request an action for the person who's here in the United States, and we don't intend for them to leave the United States, if for some reason it cannot be approved, meaning, so it's possible for the H-1B petition itself to be approved, but let's say, for example, the person was not maintaining status for whatever reason. Let's say they were outside of the 60-day grace period or any number of other reasons. So if they're not able to extend their status or change their status because of status issues or some other reason, and they have to leave the United States and get the H-1B visa stamped, then in that case, the H-1B, the $100,000 fee would apply. So there are some situations, it's not overly common, but there's some situations where we as immigration law professionals will, on behalf of our client, file an H-1B petition and ask for request to change of status or extension of status, whatever the situation is. And we think there could potentially be a problem. We identify proactively a potential issue. We let the client know, hey, this could be an issue. It could be approved as consular processing instead. Historically, that's been okay-ish. It's a big pain to leave the United States, get an H-1B visa stamped and re-enter, but it's doable. But in this situation, with this imposition of the $100,000 fee, that would be likely a really big problem unless a company just has $100,000 sitting around and they're willing to spend that on the H-1B visa. But so in those situations, that is potentially a problem. However, there absolutely is good news. Like I said a few minutes ago, we did not know for sure, the only reason that we had any information really about how this would play out is through practical experience. So in our office, we have filed H-1B petitions before the government closed, of course, for individuals that we thought potentially might be subject to the fee. So we thought that they wouldn't be, but there wasn't any clear guidance as to whether it would be applicable or not. So anyway, we have filed change of status application or petitions rather. We have clients who are cap exempt. They're not subject to the H-1B cap. So we have filed change of status, for example, from F1 to H-1B. Those were accepted and reseated without the fee. Ours that we have filed have been in regular processing, but numerous other immigration law colleagues have reported that they have had approvals in that situation and the H-1B fee was not required. So we had that information prior to yesterday, which was very encouraging. But again, we didn't have official confirmation or information from the government, but now we have it. So who does the $100,000 fee not apply to? And this is excellent information for employers and individuals who are looking ahead, especially to the H-1B lottery in 2026, because a lot of times people being entered in the H-1B lottery are already in the United States in a valid status, such as F1 status or maybe H4, L2, TN, any number of other different visa classifications. And they're seeking to change status from that visa classification to the H-1B. The excellent news is that in those situations, the $100,000 fee does not apply. So here's when it does not apply, to go into more detail. Obviously, petitions that were filed before September 21st, 2025, the fee does not apply. Visas that were approved before September 21st, 2025, the fee does not apply. Current H-1B holders, the fee does not apply. Or any foreign national, this is the really exciting part, any foreign national following a petition approval, it does not prevent them from traveling in and out of the United States. So my reading of that, our understanding as immigration law professionals, is that if there's a petition, let's say you file a petition that requests an amendment, a change of status, an extension, a transfer, and it's approved, that change of status request is approved, the extension is approved, whatever it is you're requesting is approved. And then after that petition is approved, if that person wants to leave the United States, have the H-1B visa stamped, and re-enter the United States, in that case, the $100,000 fee would not apply. Again, that is our understanding. That's kind of the widespread understanding amongst amongst us immigration law professionals. And this is excellent news. So it's not great news because, the fee is still there. And we'll talk about that in just a minute. So yes, the fee is still there. So we have a number of clients who do recruit individuals from overseas, and in that situation, if a person is coming from overseas, let's say that you have identified an employee that you want to sponsor for the H-1B lottery, and they are working in England right now, just making that up, but it can be any country, of course. If they're working in England right now, if in that situation, if you register them at H-1B lottery, they're selected, you file the petition, let's say in April 2026, as of the way things stand right now, in that case, the $100,000 fee would apply. So probably would not make sense to sponsor that particular individual. However, there are situations, many situations, most of the time when we register a person in the H-1B lottery, or we're filing an H-1B cap subject petition, or just in general, when we're filing H-1B petitions, almost always, not always, but almost always, that individual is in the United States. We are able to successfully file a request for a change of status, amendment, an extension of their status, that type of thing. So in those situations, it would not apply. So talking again about the upcoming H-1B lottery in the spring of 2026, let's say that you have an individual, again, from England, and they're here working in the United States, perhaps on F1 OPT, as an example. And you register them in the lottery, their registration is selected, you file the H-1B petition requesting a change of status from F1 to H-1B. Yes, you absolutely should be able to do that without having to pay the fee. And even more importantly, and this was not clear to us before, even more importantly, they should be able to subsequently leave the United States. Let's say that you file the petition October 1st of next year, 2026, their status changes automatically because the petition is approved from F1 to H-1B, and then they decide they want to go home at the end of the year for the holidays. Then in that case, they should be able to leave the United States, have the H-1B visa stamped, and re-enter the United States without having to pay that fee. So that's the key distinction. Is really the question is, where is the person at the time of filing the petition. Or, like I said, unfortunately, if you do have a situation where you're requesting a change of status or an amendment or an extension, and if that aspect of the filing is not approved and they say, nope, you're not in status, you have to leave the United States, then the $100,000 fee would apply. But otherwise, it does not apply, which is amazing news. There is, in the information that was posted yesterday, additional information about the national interest exception, how to apply for it, a little bit more information about the standards for that. I don't have high hopes that this would be approved. We haven't had a client yet who has needed to or wanted to apply for that. So I don't have firsthand experience, and I have not heard of any other immigration lawyer applying for that as well on behalf of their clients. So we don't have information on that right now. But the other important thing to note is that there is ongoing litigation in federal courts about this. There is no guarantee that this will be struck down, but it is being litigated. There are lawyers who are litigators, meaning they file cases in court, and which I do not do, but they file cases in court and it's being fought. So we'll have to see what the outcome of that is, but it's possible that this will be struck down by the time it's really applicable for CAP cases anyway. So I hope that you are as encouraged by this information as I am. I know it's been a long road. We've had a long time without information, a lot of stress, chaos, anxiety that honestly was not necessary. There could have been clear information from the beginning or could have not been implemented at all. But we are here. This is what we know right now. And I'm really encouraged by it. And I hope that you will find this news encouraging as well. I hope that you have found this information helpful. If so, I hope you'll share this video with a friend or colleague. Drop any questions that you have into the comments and I will answer them as I can. As always, this is not legal advice and I can't give legal advice on this forum, but I'm happy to answer general questions if I can. Otherwise, I hope that you will like this, share it with a friend, make sure you're subscribed to our channel with the alerts on so you don't miss our next video. My name is Emily Sumner with Sumner Immigration Law. We serve clients from around the world and around the United States with employment-based and family-based immigration matters. Until next time.